cause to
So,
say you
here we
violated
go.
one or more
This
of
is
the conditions to
obviously,
your parole.
you'll see about a
If you do not
chomo who
find
doesn't like
probable
to take his
cause not to
medicine,
reinstate
so
parole, which means
at
releasing
the
you,
end he
placing
got
you back on
denied
parole supervision.
and revoked,
If
and
I
this is
find
the only time
probable
I'm
cause
saying
and determine
good.
that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. CH0M0 and Officer Defendant, can you both please raise your right hands? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes.
Yes, I do.
Thank you. So we're going to go over the procedure for today's hearing. So first I'm going to read your rights. Then we're going to review the parole violation charges that the state your parole officer is bringing against you. We'll then review and identify the exhibits filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No questions. Would I be able to say something at the end of the procedure?
Yeah, Elliot, so I'm going to do most of the talking, but if you feel as though you have something to add, then that will be the appropriate time, okay?
Okay, thank you.
All right, you're welcome.
So we are going to go over the rights now for the hearing. First, you have the right to an attorney, and counsel is here present for you. You also have the right to receive a written notice that charges a violation. Did you receive that written notice?
Yes, I did. I received a copy of the warrant.
Okay, great. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights now? Are you ready to go forward?
Yes.
So you're now going to review the charges that the state your parole officer is bringing against you and the information underlying each charge. Officer Rudemaker, can you please read the charges you brought against Mr. CH0M0?
Sure. So charge 1, under obey all laws, obedience to the law. On 1/3/2025, you failed to register your address as legally required with the Connecticut Sex Offender Registry. Subsequently, a warrant for your arrest was issued, and on 8/15/2025, you were arrested by the Hartford Police Department and charged with 1 count of 54-252 failure to register. On 8/15/2025, you were arraigned at GA14 on docket number H14H-CR25-0772528-S. Charge 2, under mental health treatment. On 5/28/2025, your parole officer discovered that you were no longer taking your mental health medication as prescribed, as multiple unopened pill packs were found in your residence. On 4/15/2025, you refused to take epiprazole, Divalproex, and fluoxetine, medications prescribed to you for mental health purposes. On 4/16/2025, you refused to take epiprazole, Divalproex, and fluoxetine, medications prescribed to you for mental health purposes. On 4/17/2025, you refused to take epiprazole, Divalproex, and fluoxetine, medications prescribed to you for mental health purposes. On 4/18/2025, you refused to take epiprazole, Divalproex, and fluoxetine, medications prescribed to you for mental health purposes. On 4/19/2025, you refused to take epiprazole, Divalproex, and fluoxetine, medications prescribed to you for mental health purposes. On 4/20/2025, you refused to take epiprazole, Divalproex, and fluoxetine, medications prescribed to you for mental health purposes. On 4/22/2025, you refused to take epiprazole, Divalproex, and fluoxetine, medications prescribed to you for mental health purposes. On 4/23/2025, you refused to take epiprazole, Divalproex, and fluoxetine, medications prescribed to you for mental health purposes. On 4/24/2025, you refused to take epiprazole, Divalproex, and fluoxetine, medications prescribed to you for mental health purposes. On 4/25/2025, you refused to take epiprazole, Divalproex, and fluoxetine, medications prescribed to you for mental health purposes. On 4/26/2025, you refused to take epiprazole, Divalproex, and fluoxetine, medications prescribed to you for mental health purposes. On 4/27/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 5/2/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 5/3/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 5/4/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 5/9/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 5/10/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 5/11, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. Your actions violate your signed special parole agreement, and you signed a misconduct for your behavior. On 7/28/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 5/29/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 7/30/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 7/31/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 8/1/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 8/2/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 8/3/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 8/4/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 8/5/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 8/6/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 8/7/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. On 8/8/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes. And on 8/9/2025, you refused to take epiprazole, Devoprox, and fluoxetine, medications prescribed to you for mental health purposes.
Thank you. You've also submitted evidence that you've marked for identification purposes. Can you please identify the evidence submitted?
Yes. Exhibit A, special parole agreement. Exhibit B is the remand's actual custody order. Exhibit C is the notice of parole violation. Exhibit D, parole violation report. Exhibit E is offender misconducts. Exhibit F is Hartford PD arrest warrant. Exhibit G is photograph evidence. Exhibit H is email correspondence. Exhibit I, halfway house disciplinary action reports. Exhibit J, emergency transportation certificate. Exhibit K is the BOPP revocation summary, and Exhibit L is the BOPP decision information summary.
Thank you. I'm also identifying the halfway house agreement submitted as Exhibit F. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified for us today?
Yes.
Great. I did not receive any exhibits from the defense. Is that accurate?
Yes.
Do you need any time to submit evidence?
No.
We do not have any witnesses, so at this time, the state will have an opportunity to make a short statement calling witnesses and testify with respect to probable cause, the severity of the allegation. So, Officer Gudabenko, do you have any comments towards the charges?
Sure. So this is Mr. Chazelle's second violation for mental health treatment, for refusing to take his mental health medication as prescribed and not abiding by his special parole agreement. The evidence clearly shows prescribed medication that he was to take in unopened blister packs over multiple days and multiple weeks where none of that mental health medication was taken. The emergency certificate, where he was involuntarily hospitalized while at the halfway house, his symptoms had become so severe that he was taken to the hospital involuntarily for threatening to shoot law enforcement officers if they entered the program. And with his own statements,
just look at his eyes. Doesn't he look like a stone cold weirdo?
Violation.
This isn't a joke. You think this is funny?
No insight
Show
into
him.
his mental illness and the necessity and requirement to take his medication to treat that. I would just say the evidence shows that he's, clearly not willing to abide by the conditions of release that the board imposed with the mental health treatment condition.
Thank you. Attorney Jones, would you like to make a statement?
Yes, thank you. In regards to charge 1 under obedience to the law, we would submit that there's insufficient evidence to support a finding of probable cause. Just noting that my client was arrested on a warranted arrest from an allegation dating back to January 3rd of 2025. He was arraigned in GA14 Hartford on August 15th of 2025. And at that time, the charges were nollied at arraignment. I would note that my client was in the community for approximately 7 months after the allegations. And the reason why the charges were nollied is that my client had mailed his address verification to the registry. The mail was returned to him due to lack of sufficient postage. He then remailed it back to the registry. He contacted the registry by phone to verify receipt. He did speak with an officer at the registry who did verify that they at that time had received it. I had my investigator contact the sex offender registry to see if they could support what my client was saying, and they in fact did have notations that he did contact them and indicated that the letter was returned to him for lack of sufficient postage, and that he did in fact remail it, and that they had received it approximately 2 days later. I would note also in the warrant, it does note that at the time that the warrant was written, that the client was in compliance with the registry. Again, I also would note that at the end of the warrant, it notes that my client had 3 prior violations for a failure to register, and that information is not accurate. I do have a copy of his CSBI that I received on September 3rd, which does indicate that he has never, in fact, even been arrested for a failure to register charge other than the instant offense. So that is not accurate. He has no failure to register convictions on his record. And I could certainly pass that to you if you wanted to view his CSBI. And so for all of those reasons, we would submit there's insufficient evidence to support a finding of probable cause on that particular charge. In regards to charge 2 under mental health treatment, I would note that Exhibit H, which was submitted, which is a document back from, I believe, April of 2024, appears to be from a treatment provider at Capital Region, and it indicates that my client's in agreement with taking 2 prescription medications listed there, Abilify and Depakote. So he certainly does not appear to be somebody who's not has no insight into his mental illness and unwilling to take medication. His notations that P.O. Kudabango had pointed out that are written on the parole violation report, I would object to the characterization of those statements as being somebody who lacks insight. What my client is trying to convey there is that when he was sentenced in court, the court made no stipulations that he was to take to participate in any sort of treatment or anything as a condition of special parole, because the court doesn't have jurisdiction and can't do that. And so what he's saying is that the court didn't stipulate him to do that. He's doing it voluntarily. So my client's under the belief that when he goes to outpatient treatment, when he goes to get his mental health medication, that he's doing all of those things voluntarily, that it's not stipulated by the court. And that is simply just him not understanding that parole can also stipulate him to do that. He just believes he's doing it voluntarily. He doesn't believe that he doesn't have to do it or that he's not willing to do it. And so in regards to the mental health medication, my client was gainfully employed working 2 jobs. You can just wave your hand. I think the light will come back on. Yeah. He was gainfully employed working 2 jobs. He did have a visiting nurse coming to his apartment to help him with administering medication. However, he no longer became eligible for those services of the visiting nurse due to his income. He was over income. So what ended up happening was he had a lockbox in his apartment. The lockbox contained the medication. The visiting nurse would come and lay out a week's worth of medication for him. And then when he was no longer eligible for the services, it was on him to take the medication. The nurse came, unlocked the box, and now he has to take the medication. The medication packets do contain dates. However, if you're not following the dates and you just lay out 7 days worth of medication, it may not be following the exact dates that are there. The medication is all the same for every day. So it doesn't necessarily mean if you take a packet that says 4/17 that you can't take it on 4/18. And so I think the only thing that he probably was guilty of is not taking the exact dated packages. So we would submit that he was taking his medication. He was able to continue working, pay for his Reach apartment, pay for his car payment, pay for his car insurance, pay for his cell phone. All of those things he was able to continue doing without any issue. I believe that he was remanded after the warrant was served on him, and that's the only reason why he would end up here. He was not a danger to the community. He was not out in the community doing anything wrong. He wasn't disrupting anybody. He was actually living a pretty good life, working and supporting himself. So that would end my comments in regards to the charges. And then in regards to serious enough, we would submit that this is not serious enough to warrant continued incarceration. He's been in the community for 22 months. And I would note, yes, in 2024, there's a document submitted that a global crisis was called, but I think that's the appropriate way to have dealt with a situation where he might have been in mental distress. And mental distress does not necessarily come from a failure to take your medication. Sometimes medication stops working, and it appears as though that might have been the situation because the document Exhibit H indicates that medication was either added or substituted. It's not clear because there's no prescription telling us what exactly he was supposed to be taking. But Exhibit H does point out that he agreed to take 2 additional medications, or those medications were replacement medications. I'm not certain of that. But he certainly was in agreement with that. It was addressed. He was hospitalized, and it seems as though that was effective because he was able to come back into the community and continue to work, transition from the Aileen O'Connor halfway house to the apartment. I did contact the Aileen O'Connor halfway house, and I was able to confirm that, yes, he was there. Yes, he was medication compliant. He had no issues while he was there. And yes, he had a visiting nurse who came to his apartment. I was able to get that person's name and contact information and was still in the process of trying to reach out to that person for additional information. But taking all of the circumstances that transpired here under consideration, we would submit that even if you did make a finding that it's not serious enough to warrant further incarceration. Thank you.
Thank you. Any additional comments from either side before I take a moment?
Yes, I'd just like to respond if I could quickly to counsel's.
Okay, 1 second. And then Mr. Shazley, you'll have an opportunity once Officer Hudabanka. Is that okay? All right, go ahead, Officer Hudabanka.
So just to respond to counsel, the failure to register warrant, those are always going to be backwards looking. They're going to be retroactive. Yes, the failure to register was on January 3rd. However, it takes the state police time to see that the letter that was sent out to an address is not being returned, time for the offender to be placed into a non-compliant status, and then time for the violation itself to be generated, and then the arrest warrant submitted to the court for a judge's signature. Regardless of what the court decided on the 15th, the charge for the board is to obey all laws. It is not to be found guilty in court and sentenced to a minimum of whatever time someone else deems sufficient. There's a fact-finding hearing. There's a signed arrest warrant that failed to register, and that was signed by a judge. Prosecutors have discretion as to what they're going to do with the case. But what's not in question is that that law of failure to register was broken. In regards to the mental health treatment, and specifically Exhibit H in the email correspondence, the email from Capital Region was 1 day after his involuntary hospitalization. That is when his treatment team added Abilify because he had threatened to blow the heads off of cops who stopped him in the street. So that evidence is even more concerning because he's informing his treatment team as well as his parole officer that he's going to take the medication, when in fact we're doing the exact opposite. Regarding the prescriptions being mislabeled, again, that's just, we're assuming that a prescription is being written with the wrong dates. And even if that were the case, there's clearly multiple weeks somewhere in this supervision period then that he was not taking medications as he should. And the emergency certificate that brought him to the hospital states clearly that he was an imminent danger to the community. And that's when his mental health team added Abilify because of that imminent risk. Regarding how long he's been in the community, a year of that time was in the halfway house, as counsel stated, at Eileen O'Connor, where the medication was managed by 24-hour staffing. And I would have been notified at any time that he was refusing to take that medication. And he did have a travel nurse because myself and the halfway house staff coordinated a multidisciplinary discharge plan to ensure he would remain medication compliant so that we wouldn't end up where we are now, where he's refusing to take the medication. I would argue that these are entirely sufficient to meet the elements. And the evidence shows that without the medication, by the therapist's own argument, he's an imminent risk to the community. And he's made threats to harm people in the community.
The only thing I would add is that those allegations are over a year ago, and they're not listed as part of the violation. That's the only thing I would add. I mean, there's no allegation that he didn't take Abilify or didn't take Depakote, which were, again, P.O. Hudavenko's indicating those were added medications. I don't think the document's clear that they were added medications and not replacement medications, but assuming they were added medications, there's no indication that he wasn't taking those medications, and therefore that appears to me to show that there was compliance with the medication.
If I could just add, I mean, that's the generic name for Abilify. Eproprazole is Abilify. Divalproex is Depakote. I used the terminology that was in the evidence on the blister prescription packs. So those are those medications.
And Elliot, I would just kind of probably say, I'm not sure what you want to add. I don't know that there's any, go ahead. I don't know that there's really anything to add at this point.
Yeah. I would like to add that I just seen the psychiatrist. She canceled my medications. It was as needed. Usually I would go to Capital Region for my outpatient. And my doctor, the therapist that was supposed to be here as a witness, Damien Nuzzo, because when I see my psychiatrist, I always go see my therapist. He always gives me a call. I keep in touch with him, and he knows about the prescriptions the doctor prescribed. So the doctor prescribed my medication as needed, and I only need to take them if I needed them. Because I only requested those during COVID in Garner, and that was in 2020. I was trying to stop the medication. The doctor said he's just going to keep prescribing them just in case if I have any symptoms of anxiety or depression, and if I don't need to take them, I don't have to. And I just seen the psychiatrist last week here. She canceled the medications because they're only as needed. So if they're only as needed medications, either I take them or not. If I don't have to take them regularly, she stopped them. And that's what I told her. And they have records with Capital Region. And my therapy, my Depakote, they're only sleeping pills, anxiety pills. I've been taking those when I wasn't on parole. When I got out of parole, in 20 years before I even had parole or any type of probation, I've been going to outpatient therapy on my own for years, and it's not court stipulated and it's stated by the judge and the prosecutor. I also, when I have an open habeas case. I have no parole stipulations to go to any programs or any mental health treatment or anything, or they will subpoena the parole officers to programs, and he knows that. And
well, that's okay, Elliot, that's through the court though. So court and parole are two different things. Okay. All right. Okay.
I'm so
all right. Okay. All right.
Can I ask for quick clarification, Mr. CH0M0? You said you saw someone last week. You mean at Carl Robinson?
Yeah. Yes.
I took you off? Okay. All right. Just wanted to confirm. All right. So I am going to take a moment. I'm going to take a quick recess, and I will be back shortly. Just so everyone knows, we are live streamed. So just no comments, please. Thank you. Pause for the
As you see, he was denied, but like I said, stay blessed and stay free.
D, E, H, and G. And I do want to point out an Exhibit H. The doctor did mention that the medication prescribed to Mr. CH0M0 is not as needed. It is daily. So that's the findings for today. I'm also finding that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you await your revocation hearing. So the records office at the facility will be notified of this, Mr. CH0M0, and